Am I here?
Can you hear you?
Yep. You're Phil. You got to turn on your video.
I'm trying to do that.
I believe I can
Probably
see.
better without it. Oh, there it
There
is.
you are.
And Mr. Brown, we can. Could you say something? We see you, but we don't hear you.
Okay, how about now?
We can hear you. No, we can't see video of you. We just can eye contact.
I'm sorry?
We can't see your. We don't have video on for you. We just see a box saying that you're here. Are you able to turn on video?
Okay. I'm launch meeting. I'm heading that.
So we launch meeting. If you're on,
I'm seeing you.
great, good. If you're on Zoom, it would be in the bottom left-hand corner. There's a mute icon and a stop video. If you click on stop video, it should start the video.
Okay, but I don't see that. I'm looking on the bottom left. You hear me? Right.
I can hear you.
Okay, good. But you don't see me.
Don't see you. That's correct.
Okay. I see launch in there. Would launch be the thing I hit?
I don't believe so.
I'm looking at mine, Mr. Brown. There's a microphone that says mute underneath mine. Right next to that, there's like a camera that says stop video, and you can.
Yeah, I just don't see. I just don't see it. There's a Zoom software. Gosh. Well, I'll experiment a little bit.
Okay.
Carly,
Carly, do you have?
I see Carly's name.
Yeah, I just sent you a screenshot of what you should click. So do you see all the boxes with everyone in it?
I see everybody. Yes, I do.
Okay, so I sent you
Oh, there it is. I
left.
see it now. I see it.
Yeah.
Start the video. Okay.
Yeah.
It wasn't there before.
Yeah, there you are.
Okay. It didn't come in before. Sorry, guys.
No, that's great. Now we can see you. Okay, so we'll go on the record. Today is September 10th. We're the Board on Professional Responsibility, and we're here in the matter of Alvin S. Brown, which is board docket number 19-32, disciplinary docket number 2017 D342. Let's have the parties identify themselves for the record. Let's start with disciplinary counsel, Mr. Fox.
Hamilton Fox, Office of Disciplinary Counsel.
Thank you. Mr. Brown.
Alvin Brown, respondent.
Okay. So, Mr. Brown, you were the one who filed exceptions. You've got 20 minutes. Do you want to reserve some of your time for rebuttal?
Yes. Let me try and break it up until 10 and 10. Okay, so I'll speak for 10 minutes and then reserve 10 minutes as rebuttal.
Sure.
Okay.
All right, so before we get started, just a couple of things. We're, as everybody knows, we're in a global pandemic, and as a result, we can't meet in person, so we're doing this by Zoom. A couple of things with that. First, if you're not speaking, please have yourself on mute. That goes for everyone, both folks who are arguing and board members, and staff from Jim Phelan's office. Then if you are during the argument, just because Zoom can make it a little bit difficult to talk at the same time as somebody else, the way the audio works, board members are going to raise their hands if they're having trouble breaking in. So if you're arguing, Mr. Fox, Mr. Brown, and you see a board member with a hand up, please try to
Hold it. Okay.
and I'll try to play traffic cop on that a little bit. One final note for today. I hope that this doesn't happen, but as anyone in Washington, D.C. knows, there's severe weather today. We may have internet connectivity issues for some folks with this. If it comes to that, we'll continue with the argument unless it seems like we've lost so many board members that we can't meaningfully continue. And we'll sort of deal with it there. So if you see somebody disappear, we'll keep going. Okay, with that, Mr. Brown, please start at whenever you're ready.
I am ready. My reply memo, I thought, was pretty direct, and I'm going to simply cover some of the points in the reply memo. The most important issue, and it's a threshold issue, the board believed and took the position that the engagement agreement was one for an offer and compromise based on economic hardship. That's just not true, but because of that, the entire charges, just about all of the charges, assume that there is an offer and compromise and made charges based on those facts, which were not applicable. So
I'm going to interrupt there just for a moment, Mr. Brown, because that is something I would like clarity on, if you don't mind. So my read of the record is that an offer and compromise is something that you would use when you want an economic hardship relief.
Yes, that's correct.
At least in New York, and that there's also an abatement process if you were looking for relief from like tax liability or penalties of that nature. And so putting aside the titles of the various things, could you explain to me what was the strategy here that you were going to employ for your client to try to reduce his tax liability?
Very simple. The client said that he had a liability that he wanted abated. Liability, I underscore the word liability. And my engagement letter addressed that. I gave him the option of making my services based on the liability or based on economic hardship, which would be the offer and compromise.
So I'm going to interrupt then. So you said abatement. I just want to make sure I have it clear. So you were looking for your strategy was that you were going to ask for a reduction of the tax debt, but you were not going to do so by saying there was an economic or financial hardship. That was off the table.
That's correct. And also you missed a point of analysis, and that is that you can have a contract based on a liability. I'll give you an example of a person that is a responsible person for sales tax or payroll tax. Who is the responsible person? That's a pure liability issue. So I address the contract as a pure liability issue. That's not one of the choices that you gave me.
Can I ask how you get there? Because I'm looking at sort of the relevant part of the engagement agreement, and I'm not sure your construction of it strikes me as the most intuitively correct one, and I'm wondering if you can.
I'd be happy to. I got an email from Mr. Bari telling me on February 12, 2016, that he has a sales tax liability that has many extenuating circumstances. So he identified a liability. So the engagement agreement says, I need a statement from you about the unfairness of your sales tax liability. Alternatively, if there's an economic hardship that caused the sales tax problem, I'd like a full discussion of those facts. Bari responded to that engagement letter by only focusing on his liability. He did not focus.
Let me ask you this, because so the engagement agreement, it's labeled engagement agreement for New York sales tax offer and compromise settlement agreement.
Yes.
Right?
Yeah. Now, let me give you a little bit of information. The District of Columbia, Virginia, Maryland, and the IRS have forms that allow you to submit an offer compromise that that covers both economic hardship and a liability.
Okay.
So, so I've spent a lot of years dealing with pure liability issues.
Sure.
So I see this as a pure liability issue.
But it looks like New York doesn't, right?
Exactly. That's really the crux of most of my problems in this matter. Yes.
This was a New York tax matter, right?
Yes, it is. But in fairness, I know that now. Looking back, I didn't know it when I started.
Yeah, although, I mean, here's my question. Well, why wasn't it your job to sort of figure that out before you took the representation on, or at the very beginning of taking the representation on?
It didn't cross my mind that New York would not have a pure liability form that would allow me to address a pure liability, because the IRS has it, DC, Columbia has it, Maryland has it, Virginia has it, a lot of states have it. And I've never come across a situation where it didn't have it. So I did not do that. I did not find that out before. I didn't do the research beforehand, but I just assumed it was there.
Okay, let me ask just one follow-up question to something you said just a second ago. I saw your hand, Mr. Walker. If you don't, thanks. You put a lot of weight on the word liability. And yes. I wasn't sure I understood it from your briefs, but I think I'm understanding it the way you're using it now. Where, tell me if I'm misunderstanding you. A liability, as you're thinking of it, is a relatively technical term in the tax world. That means you are challenging whether the tax was correctly imposed, and you're trying to undo the original imposition of the tax. Yeah. Is that right?
Yeah, the abatement procedure does that. But there's another way to attack it, and that's normally in the world other than New York, there's a form that allows you to address a pure liability issue.
Yeah, and so I guess what I'm wondering is, as I look at the language in the engagement agreement, that for $4,000 you would endeavor to get Mr. Bahari's sales tax liability settled.
Yes.
It strikes me there is this other sort of common sense or ordinary person use of the word liability, which just means like a debt.
Well, so he has a 2003 sales tax debt. So he says, okay, I'm good with that. I caused that. I'm responsible for that debt. I simply want the additions, penalties and interest for the years after 2003, 4 through 15. I want that abated. I want that settled. I want to get rid of it. So that's part of his liability. So he's segregating part of his liability and said, this is what I want to get rid of. So he's asked me to get rid of a liability.
I mean, do you think he understood liability that way?
Yes, because when I gave him his choice of addressing the liability or economic hardship, he did not address economic hardship. He never told me, he never responded to that option. And throughout the engagement, he never addressed an economic hardship.
Oh, but is that his job? His job as the lawyer.
Pardon me?
Is that his job to affirmatively address or not address, or your job as the lawyer?
No, I asked him his choice. I'm telling you that it's my contract. I wrote it, I interpreted it, and I gave him a choice between my working on a liability issue or my working on an offer in compromise based on economic hardship. You understand that difference, I'm sure.
Well, why didn't you resolve that before you did the engagement agreement?
Well, that's the question you asked before. I didn't do that. I did not do that. And I don't do research on something before I start it. But the stronger point is I've never known a jurisdiction that didn't address a pure liability. So now I've been around I've been a tax attorney for a long time. I have strong tax experience. So I've had a lot of cases dealing with who is the responsible person. If somebody is signature has a signature on the bank account, are they a responsible person? I've had tons of issues like that. The answer is there's a lot of case law that says that person is not a responsible person, not liable for the sales tax liability or the payroll tax liability. So it's an issue I've addressed my whole life, a pure liability issue.
Well, so Mr. Walker, I think, had a question.
Yeah, so focusing on this particular matter and at this particular point in your tax career, do you accept any responsibility for what appears to be or has an insufficient communication with your client? And I mean, whatever you're saying, the client seems to have thought otherwise. So it's a two-way street. No. Do you? And I'm not exactly sure how the starting point that you've articulated explains what appears to be failures to communicate and keep the client informed. How does it do that?
Well, I think when you look at the engagement agreement, it's clear. I'm giving him a choice.
No. I'm not talking about at the start of the engagement. I'm talking about throughout the engagement.
Yes.
There appears to be a record of failure to communicate on your part and to respond promptly to client requests for information. Do you acknowledge those failures?
Well, I'd like to address that and the way you put it. The point that we've all agreed on is New York does not have a pure liability form. I spent the entire period of engagement looking for it.
Let me interrupt, Mr. Brown.
No, I'm answering your question.
With all due respect, I don't think you are. How do you get to what appears to be a failure to communicate throughout with the client?
You have to have information to tell the client to give the client data. If I can't get started in this case unless I have a New York form that allows me to address the liability. So I spent umpteen days or hours trying to find that document. But during that period, I had nothing to give Mr. I couldn't give him any information because I had none. I was doing research. So when you do research, you don't have material facts that I can give him. So my answer to you is I had nothing to give him. I would have been happy to give him an update on information, a communication with New York. I had nothing because I was still engaged in trying to find that elusive form that I now know doesn't exist.
And did you communicate to him throughout that, hold the phone, I have nothing to report yet? Did you keep him updated?
No, I never tell my client that I'm in the middle of research. That doesn't come up. In this case, I did not tell him that I was in the middle of doing research. But in the meantime, what I did do is try and solicit from him information that would justify abatement.
So, Mr. Brown, let me ask you, and I know you're out of time, and so do you want me to wait for rebuttal, Mr. Fraser? So Mr. Brown, so in this case, I understand that your strategy was liability. You wanted to see if you could abate, whether it be the underlying tax liability itself or the penalties and interest.
Yes.
You're basically just trying to reduce the debt.
Yes.
All right. And I understand, and I'm going to accept that that's what you put before your client as these two options, the financial hardship and the abatement, and he selected abatement. I'm going to assume for purposes of my question, that's the case. You said that you were trying to research an abatement form for New York, but you never found one. So I guess I have two questions for you.
Yes.
One is you ultimately did submit an offer and compromise to the New York Tax Authority.
Yes.
And my question to you there is, how did that advance your strategy? And my second question is, with regard to the testimony from the individual from the New York Tax Authority, I believe his name is Mr. Hawk or Hauk. He did explain that there was an abatement process. Did you ever follow through with that abatement process?
No, I'll answer both questions.
Okay.
With regard to the abatement process, I didn't even know about it at the time. But what the abatement process does do, it says that you can question the assessment. So in this instance, you can question the assessment if you have reasonable cause to justify a challenge to the assessment. So Mr. Bari,
I just want to make sure I understand. You're saying you did not know about this at the time that you were doing the work for your client?
Well, it's no different from any time you get an assessment and then let's say the IRS has an assessment, you have a right to appeal it. So I was given a project where the tax in 2016 where he wanted abatement for the years 2004 through 2015. It wasn't like they just made an assessment where I can appeal it. So the other point, even the stronger point, is that there has to be reasonable cause under the abatement procedure to abate a penalty. And this, that takes a little time to explain it, but his claim, his justification for abatement was that he wasn't aware of the assessment. He was living in France. That's hearsay and self-serving. It's not reasonable cause under the New York tax regulation. So had I done that immediately at the time there was an assessment, let's say in 2004, I was engaged in 2016, I would not have been successful on behalf of Mr. Bowery using the abatement procedure.
Okay, thank you. So at this point, we're sort of well past time, and there's a meaningful amount of time in rebuttal. Why don't we hear from Mr. Fox? If I could ask you, Mr. Brown, to mute your microphone, we'll come back to you in after Mr. Fox is done.
Okay, let me find it.
Sorry, it should be right next to that button that turned your video on.
Oh, I'll just mute. Oh, I can mute my sound. That doesn't help me. I don't.
Okay, thank you, Mr. Fox.
Good afternoon. I don't know exactly how to start with this, because these arguments that Mr. Brown is now making were not only never, they're things that he never informed his client of, and he never even made these arguments to the hearing committee. This contractual argument that he has entered into a contract only to seek an abatement arose for the first time in his brief before the board. In fact, if you read his reply brief, he chastises us for unsubstantiated allegations, because he says we only assert the allegations that were found by the hearing committee report. Well, yes, that's true, because that's what we're supposed to do. At no place, and I'm faced kind of here with the position of proving a negative, but at no place in any of his communications with Mr. Bowery, his client, did he ever say, you have two choices. You can do an abatement, you can do an offer and compromise. Here's the difference. What do you want? None of that. The hearing committee found, as a matter of fact, that Mr. Brown did make the argument that Mr. Bowery couldn't get an offer and compromise because he couldn't show financial hardship. And the hearing committee found, as a matter of fact, that Mr. Brown never asked him that question, never asked him if he was raising financial hardship, if he could show financial hardship. So all this contractual argument, which does, frankly, I can't see in the contract to begin with, but it's completely after the fact. The pure and simple answer is that Mr. Bowery is not an expert in New York tax law. He hired someone who he thought was an expert in New York tax law. He wanted him to endeavor to reduce his tax liability. He's a layman. If there was this difference, and there is a difference, but if this difference between an abatement, an offer and compromise, and how to proceed, it all should have been explained to him. He should have been given the choice. Instead, Mr. Brown did whatever he did, and for 8 months, it appears he did nothing. And then he filed an offer and compromise, which he now says he was not hired to do. And he didn't file the necessary papers that you need to go with an offer and compromise, particularly the financial statement that the state requires and that the state asked him for. And he never even went back to Mr. Brown and said, we need a financial statement. What can we show? He just dropped the ball completely. And frankly, I think that the explanation for that you just heard from Mr. Brown, which was he was familiar with systems in Maryland, Virginia, federal system, where there apparently is some unified form that you can file. And on that form, you can ask for an abatement, or you can ask for an offer and compromise. I don't know, maybe you can ask for lots of other things. He couldn't find that form. And so he didn't know what to do. And essentially he did nothing. And this contractual argument that he has come up with before the board is a complete post hoc rationalization. And there is nothing in the record to support it.
Mr. Fox, can I ask you a question on the 1.3 violation, the 1.3B? Or no, I'm sorry. Yeah, that's right. The intentional failure to seek client's lawful objectives. So I do think one of the things that seems to be present in this record is confusion over the fact that this offer and compromise means one thing in some jurisdictions and it's more limited in New York. Is there in the record sort of a good faith argument on the part of Mr. Brown that he thought he was doing the right thing by completing the offer and compromise in order to reduce the tax liability, because he did not know it was limited just to financial hardship? And if so, where do we get the intent you need for a 1.3B violation?
Well, I think what the facts would show, first of all, it's not clear that there are these limitations on the offer and compromise as Mr. Brown claims. That's Mr. Brown's assertion. He's not cited any case law. He's not presented any evidence about that, but assume for the moment that's right. His client said, I don't want to contest the almost $15,000 in liability. It's just a penalty and interest. Mr. Brown, without telling his client, without showing his client in advance, who had asked to see everything, files an offer and compromise, and the offer is $1,000. He gets back, the materials that he had showed him that he had to put a financial statement with that. He gets back a request from the state of New York that says, you need to file your financial statement by November such and such. And if not, we're going to essentially dismiss this without prejudice. He doesn't do anything. He doesn't ask his client. He just drops the thing completely. And that, to me, it seems, is the intentional failure to seek the lawful objectives of the client. And I don't understand why he filed the offer and compromise in the first place if he claims there was no way his client could get it. But he says he did it. At one point, he made some testimony that it was some kind of a ploy to get the ball rolling for negotiations or something like that. But whatever the reason was that he filed it, he dropped it. He didn't tell his client about it. A couple of weeks later, his client, who's at this point pretty irate, is saying, what's going on? What's happening? At that point, he tells the client he's filed something. The client said, well, can I see it? He sends it to him. And the client says, well, wait a minute. I told you I wasn't contesting the basic tax liability. I'm just contesting the penalties and interest. That seems to me to be pretty definitive failure to follow the lawful objectives of your client. If you're going to decide that the way to go is an offer and compromise, you need to file complete papers for an offer and compromise, and you certainly shouldn't just drop it without even consulting your client. I think I forgot to mention in that factual litany that he never told his client, once the state told him that you needed this, that we're rejecting the offer and compromise and let you file this financial statement, he never even told his client about that. So yeah, I think that's intentional failure.
Can I switch over to the flat fee issue? So here the argument is that Mr. Brown did not earn his flat fee because he did not, I believe your argument is that he did not complete what he had agreed to complete for his client. Could you explain to me what Mr. Brown needed to do? And in my hypothetical that I have before you, let's assume that he takes the case, researches the factual scenario, and ultimately decides there is no avenue for relief. Could he still earn that flat fee if that were the case? He adequately researched it and discovered offer and compromise isn't going to work, neither will abatement. There is no avenue here, unfortunately. Could he earn that flat fee?
I think the answer to that is no. But but that is a purely hypothetical question.
I understand that. That's why I labeled it one.
Yeah, no, because there's nothing close to that happened.
Well, I mean, on those facts, could he earn a portion of the flat fee? I guess that's what I'm sort of wondering. And forgive me that I tend to think of flat fee, from the litigation context. But it strikes me, if you're hired for a flat fee to do a case, and you do the first part of the case, the motions right after the complaint's filed or the pretrial motions in a criminal case, that you would have earned a portion of the flat fee, and that's that in Mance and in the ethics opinions after Mance. And
I don't think so, and I think, if you'll forgive me, I think lawyers who are used to charging their time on an hourly basis sometimes have a hard time grasping this concept, and I think Mance is the case that explains it. I mean, if you say, I'm going to do something for a flat fee, you got to do whatever it is you promised. You don't do half of it. And if you do half of it, you don't get paid for it. If you hire me to file a complaint and
Really?
I research the complaint and tell you, I mean, I enter a contract with you and say, I'm going to file a complaint for you. And I research it and I say, and this goes back to Ms. Pittman's question, and I say, well, this complaint's not going to fly. It's no good. So I'm not filing this complaint. Then I think you got to give the money back.
look
Uh,
at 355, right? I mean, if you
Sorry, I could not hear that.
opinion 355, right? If I've got a flat fee where I say, hey, I'm going to represent you in this bit of litigation, and we're going to earn the fees are going to be earned on the following schedule. I file the complaint. That's 10%. We survive summary judgment. That's the next 30% or whatever. And all of that is set out. What the ethics committee says there is doing it that way is the preferred way to do it, because then if you get conflicted out of the case after the complaint's filed, you know what you've earned and the client knows what you've earned, and then you get a portion of the flat fee. And the reason you do that is because then there isn't a dispute later about how much work you did and how much of the fee is earned. In the absence of that, you have this sort of murky world where maybe the complaint was worth 10% of the fee, or maybe the complaint was worth 3%, or maybe it was worth 25%. But there's still the assumption under opinion 355 is still that when you do some of the work on the case, some of the fee is earned.
Well, I think
With you that, and I think we saw this in Ponds, right? That it's not, if your hourly rate is $400 an hour and you charge a $4,000 flat fee, you don't earn $4,000 after you do 10 hours worth of work. You've got to sort of, the amount that you've earned is by reference to the amount that you've contracted for in the flat fee. My question is, though, if you do some of the work, if Mr. Brown filed the offer of compromise, there were follow-up questions, and he got conflicted out somehow at that point and handed it over, would he have earned a portion of the flat fee?
well, look, I'm not, let's put quantum merit aside, because that's, I think, what you're talking about here.
Sure.
You're talking,
For the restitution claim, wouldn't quantum merit matter?
well, it would, but okay, but
I mean, that's where the rubber hits the road here, right?
First of all, it's on the lawyer. He's got the right to contract, okay? And if he doesn't write a contract like the one you described, which says, I get 10% when I do this and 20% when I do that, that's on him. That's the first point. Now, second, if you get into a situation where a lawyer does some meaningful work, and I would suggest to you that Mr. Brown did no meaningful work, but that where a lawyer does some meaningful work to advance his client's case, and it turns out he's conflicted out, to take your example, then I would think he would have a claim in quantum merit, yes. But if you take a flat fee to do something and you don't do it, and you contribute nothing of value, I mean, what value has Mr. Bari received from Mr. Brown's services? The liability went from 68,000 to 100,000, but he's received no value whatsoever. And
So Mr. Fox, is there a relation between your argument here and the 1.1 competence determination? Because I think the big elephant in the room here is that we have a respondent who had what seems to be a pretty straightforward, I'm looking at the hearing committee report finding in paragraph 14, just setting out the statutes in New York for an abatement and the standard for an abatement and the testimony from the expert that based on the facts that we know about respondent's client, it should have been a pretty straightforward application for abatement. But we see in the record, and we've heard from respondent in his direct argument, that he had no idea of such a thing. And I think he may have even just said that his client wouldn't have qualified, when clearly on this record of findings, he would have qualified. So is there a tie to be made between your claim that none of the, your argument that none of the flat fee was earned and the fact that clearly respondent, based on these findings, the findings are he was incompetent to handle this matter?
I think there is, in the sense that if you take a case on a flat fee basis and you do incompetent work, and let's say, to go back to Mr. Kaiser's hypothetical, that you're interrupted by a conflict or something like that and you can't complete the work, I would think under those circumstances you would have no quantum merit claim because you hadn't done anything competent that would have advanced the ball. So yes, I do think there is a tie between the two in that sense.
Do you mind if I take you in a different direction, Mr. Fox?
If I mind, are you not going to take me?
Can we talk about fitness a little bit?
Yes.
I guess as I look at the finding we've got to make on fitness, I'm wondering, it looks like one way to understand what happened here is that really the problem may have been that Mr. Brown has a lot of experience as a tax practitioner in other jurisdictions, but not very much in New York. And that the problems here arise from trying to practice in a tax system that he was not familiar with. That may be one way of looking at the facts. And if that's the case here, I'm wondering how we get to the finding that we need to reach, because it looks like the problems that have been identified to support the fitness determination by the hearing committee are really, New York-based problems, and then problems with the course of, sort of the litigation in this case. And I'm wondering if that's how we get to a conclusion that that's enough to support fitness.
Well, of course, the issue that you're dealing with is whether there's a doubt about his competency to perform in the future.
Right.
And if you take that, if you say, well, he wouldn't be competent to handle a New York tax case, he wouldn't be competent to litigate a disciplinary proceeding, but maybe he'd be competent to handle other kinds of tax cases. But the problem that I see with that position is he has no understanding of what he did wrong in New York, as far as I can tell. He has no understanding of these proceedings. He filed a brief in these proceedings without referencing a single thing in the transcript, and that's kind of pretty basic stuff that you don't learn, you learn in law school. And the hearing committee heard him and observed him, and their conclusion is that he was confused about, and I know it offends Mr. Brown to say this because he claims it's an ad hominem argument, but you make ad hominem arguments, and unfortunately in the disciplinary process, that's what we're doing. But he was confused. He didn't understand this system. He didn't understand New York. He hasn't grasped it to this day. He hasn't grasped that we're not dealing here with a malpractice case where we're trying to, prove that the damages that Mr. Bari suffered because of his representation. He just doesn't understand. And I think the hearing committee came to the logical conclusion that Mr. Brown is no longer fit to practice, or certainly that there is a substantial doubt, which is the Cater test, that he is fit to continue practice without him so demonstrating that he's fit.
Although even in an IRS, I mean, it looks like Mr. Brown has had a lengthy career representing people in tax issues with the IRS, with Maryland, with the jurisdictions in our region. I guess I'm not sure how you. I guess I'm having a little bit of trouble seeing the fitness determination about his ability to practice on that class of cases.
Well, let's take the court's recent pronouncement in the Latimer case.
Sure. Yeah.
In the Latimer case, the reason the court imposed fitness because Mr. Latimer never appreciated what he had done wrong, what was wrong with his conduct, how he had not represented these clients the same way. And that's exactly the situation that you have in front of you today. That Mr. Brown doesn't understand. And I suggest to you that you have to have a substantial doubt that if he takes a case for another client, that he's not going to perform the way a competent lawyer should perform. And I don't relish saying that, and I know it offends Mr. Brown, but I think that's what this record shows. He's not going to be able to acknowledge the fact that he utterly messed up this case. And
So-
frankly, an experienced tax lawyer, it took 2 phone calls to identify the person in the state of New York who knew how to handle these matters. And an experienced tax lawyer spends 8-12 months on it and can't figure out how to do it. That to me suggests there's a substantial doubt about his ability to practice consistent with the ethical rules in the future.
Mr. Fox, you said something, and I follow your argument. I just want to push back on one notion that you had, which was this. I think you said Mr. Latimer never appreciated what he did wrong. And it sounds like that your position is if a lawyer, without assessing why, says, well, okay, I have been found to violate those rules, but I don't appreciate it, or I don't agree with that finding, that automatically means that they need to go to fitness. The way you described it, it sounded like to me that unless a lawyer endorses the conclusions of the hearing committee or the board or the court, they then are now in a position of needing fitness.
No,
Can you clarify that assessment a little bit more, like give it a little bit more, refine it a bit if you can? What your
Ms. Cassie,
argument is.
I don't mean to go that far.
I didn't think.
I was a defense lawyer for a long time. I understand that people have they don't have to agree with every judicial decision that comes down against them. But it is nevertheless one of the aspects of that you take into consideration as to whether the person realizes the consequences of their misconduct and so that they will not do it again. And in Mr. Latimer's case, I think what the court was saying was he had obviously, in one case, really, and it was kind of like this, incompetently handled a case, very different kind of case, but incompetently handled a case. And he never appreciated it. He insisted to the bitter end that he had done everything fine. And that gave the court doubt under the facts of that case that he would behave ethically in the future cases. And I submit to you that in this particular case, given Mr. Brown's appreciation or lack thereof of the conduct in which he engaged, that you have to reach the same conclusion.
One quick follow-up question on that, Mr. Fox. I've forgotten the details of Latimer, but here we have misconduct that's limited to one representation, and as my colleagues have noted, is perhaps a representation not in the respondent's normal practice. Did Latimer involve a one representation issue? And if not, are there cases you can point us to that found fitness in that kind of a circumstance?
The answer is no and yes. With respect to the first, Mr. Latimer's case involved 3 representations, but the incompetent conduct, well, the first 2 were simply failures to communicate. The incompetent conduct that really never appreciated was primarily in the third case, which was a wrongful death action that he filed. So the answer, I guess, to your question is no, there was more than one case, but I think it was one case in which they focused. as to the second question, whether there's a case of fitness where there was only one case involved, I'd say to Yelverton. And Yelverton was the case where the reason for the fitness was not so much what he did in the one criminal case that Mr. Yelverton handled his entire career, but it was with the fact, the way he conducted himself in the course of the disciplinary hearings, and his failure to appreciate what he had done wrong and the way he conducted himself in the disciplinary hearings. The court said that gave them substantial doubt, and they imposed fitness on I think a 30, it may have been 60 day suspension. So yes, I would cite those two cases too.
Thank you.
Thank you very much, Mr. Fox. We're well past time. Mr. Brown, you have 10 minutes.
Well, I want to let you know that Mr. Fox misled the court and told you something that's inaccurate and untrue. And it's a key point and a key fact. He said that I never asked Mr. Bowery about whether or not he had an economic hardship. It's in the engagement letter. It's in the engagement letter. The engagement letter gives him a choice of my servicing him and helping him on a liability issue or handling an economic hardship. In the engagement, and it's, you have it. It's there. And why would Mr. Fox say I never asked? It's in the engagement letter. How could Mr. Bowery not know that he has a choice of getting a liability? And by the way, his response to my engagement letter was to address his liability. He sent all the data that involves his liability to New York for 2003, including tax returns that he signed as an officer of the corporation he was working with. So,
Mr. Brown, if I can interrupt for one moment on this, on this, it was in the engagement.
I've had a lot of interruptions and I've had very little time to advocate for myself.
Well, I think you've had some moments to advocate here, and I think, you know, us asking questions teases out issues that we'd like you to explain for us. And
well, this is a threshold issue, of what the contract is for.
Mr. Brown, I understand that. And I'm going to ask you a question that I think is going to at least help me understand what you're trying to say here.
Please.
Are you taking the position that let's not even make it about you, when a lawyer gives their engagement letter to the client has to rely on the four corners of that document to determine what the scope of the engagement is and what the strategic plan and the possibilities of an outcome are? That's choice A, your position that the client relies on everything in the engagement letter. Or do you believe that there is a responsibility on the part of the lawyer that when they give the client the engagement letter, that they also have an obligation, and I'm not talking about doing legal research, an obligation to explain the parameters of that engagement letter to the client, so the client can say, I don't want choice A, I want choice B. Which is it? The four corners of the document or an obligation to explain?
Yeah, I'm not a contract attorney, but we're all familiar with contract law, and contracts are interpreted according to the terms of the contract. So this is not a complicated issue. I'm offering to help him with a liability issue. Alternatively, I'm offering to help him if he has an economic hardship. Now, I have worked offering compromise cases in New York, installment agreement cases, and I've dealt with collection issues in New York. So I am familiar with New York case law. I know what an offering compromise is. And an offering compromise requires an analysis of his financial data, his income, his expenses, his assets, his liabilities. When I asked him in the engagement letter whether he had an economic hardship, he never addressed it throughout the engagement. He never told me he had an economic hardship. So when the hearing board on every rule said that I didn't reply to the Department of Finance on their request that I fill out a financial form, I'm not going to fill it out because I'm not doing an offering compromise for Mr. Bowery. I'm working on a liability issue. Now, the entire all of the charges and that were levied against me, except for the fee issue, they all addressed very heavily on the fact that this contract and my responsibilities were to help him with an offer in compromise. Now, on basic contract law, you don't do things outside the contract. If you're going to buy a ticket to go to Chicago from District of Columbia, you can go by bus, you can buy train, you can buy airplane. Each is a separate contract. You're going from District of Columbia, but to Chicago, but they're separate contracts. So I'm asking the board to judge me based on the terms of my contract and the work that I'm trying to do under the contract. Mr. Fox misled the board by saying I never asked him about economic hardship. And that's clear. He never even read the engagement letter. If he read it, he would see that I asked that question. I'm sorry for sounding a little emotional, but this is what I call the threshold issue that the hearing board has not allowed me to address. So all of the charges against me, or most of them except for the fees, are based on the fact that I failed to help him with an offer of compromise. Something that's not covered by the engagement agreement. That's unfair. So I believe in contract law. I've read contracts my whole life. I'm not a contract attorney, but this is not a complicated contract. It's a simple one. I offered to provide services for him to help him with a liability. That's straightforward. How could it be worse? It can't be more simple than that. Now, I've done that repeatedly throughout my career, helping people with pure liability issues. And it comes up mostly on payroll tax liability. In this case, it's a sales tax liability, but the issue is the same, identical. So I'm familiar with the issue. I'm familiar with the basic contract law. So your suggestion is that I somehow have to tutorial him on whether he understands the contract. But I think it's simple there's nothing complicated that needs interpretation in this engagement agreement. It's not it's simple. And so I just object to the fact that all of the charges against me are I didn't reply to the Department of Finance of New York. Well, I don't do that because the other thing here is that it didn't come up so far in my presentation, but if I were doing an offer compromise for him, hypothetically, if I were doing it for him, it would fail because he took the money from New York. He closed his business and kept the money. He stole the money. He took it. Now, New York will only clear an offer and compromise if it's in their best interest to clear, and their offer and compromise cases are published. So it's my assertion, and it's an obvious one, that New York would never approve an offer and compromise for Mr. Bari in his case because they would be abating a tax liability based on money that he stole from New York, and those offer compromise cases in New York are published. So
wasn't your client not really disputing the underlying liability, and he was just asking you to handle sort of the penalties and interest anyway?
Yes, yes.
So then, even if he's admitting or acknowledging to you as his lawyer that he is liable for the underlying tax debt, and he's only interested in basically negotiating a compromise as it relates to the interest and the penalties, why didn't you consider that in determining how you would proceed on his behalf?
Yeah, I'm glad you brought that up because it's an important point here. If this were a contract for an offer of compromise, he would want his underlying tax liability abated. So I can't tell you hundreds and hundreds of offer and compromise cases, and I've never had a client who only wants part of their liability abated. So if I were Mr. Bari and I had the opportunity to do an offer of compromise, get all his debt settled, because he doesn't have the money, there's economic hardship, he can't pay it, and he needs money for his necessities. So he deserves to be abated. He would want all of it abated. There's no reason why he would want to keep his 2003 tax liability and make that part of an offer in compromise. So that's another reason it was clear to me that he did not intend an offer in compromise. Now, when your question goes to how I filed it, I filed the DTF-4 with a memo saying this is for, I'm challenging only a liability. And the response I got back from New York was, you can't do that on this form. We're only going to address an offer in compromise. In other words, the DTF-4.1 can only be used for an offer in compromise. It can't be used to settle liability. So they wanted me to give them a publication 5 financial statement. I would not do that because that was not part of my contract to get into the economic, his income, his assets and so on, i.e. the economic hardship issue, which is excluded from my contract. So,
sir, in terms of the scope of your contract, is it your contention that your representation agreement, the way it's worded, outlines the full extent of every single thing that you're supposed to do as a lawyer on behalf of a client in order to effectuate their goals? That if you deviate from the statement whatsoever, that you are somehow, or the client is somehow not compensating you for effectuating their goals, even if it's not specifically every single strategy or anything that you would pursue as a lawyer, that if it's not in that contract, you are not required as a lawyer. Let me finish the question, sir. That you were not required to do whatever you could, whether or not it was specified in your representation agreement or not.
Listen, if New York had this elusive form that they don't have, that would allow me to challenge the liability, and the liability then is challenged. There's nothing more to do. So,
we keep repeating the same stuff about this form and whether or not you were allowed to contest liability that way. My question is whether did your representation agreement in your mind allow you to deviate in any sort of way in order to effectuate the goals of your client? In other words, did your contract restrict you, or your representation agreement restrict you from being able to do what you were supposed to do in order to effectuate his goals?
Yeah. Well, the issue didn't come up. In other words, he didn't identify any other thing that he needs help with. So I do that for clients. I help them with other related.
Isn't that why they're coming to you, sir, as the lawyer, to identify what needs to be done in order to effectuate their goals? Because certainly if he knew what he needed, he wouldn't have hired you or needed to hire you, right?
Look, the issue is quite simple. Am I responsible for filing an offer in compromise based on economic hardship for Mr. Bari? And I wrote the contract. I know what it says. I know what my intent was. When I filed the form, I limited to a liability offer. He did not address at any time during the engagement agreement that he was suffering an economic hardship. He not once. And he didn't answer my question. That's in the contract. Do you have an economic hardship? He never said he did. If he said, hey, I think I got some problems here, then I would have gone in that direction. I would have gone, I probably would have done that. But I didn't get that from him. But it's very simple to me as, do you have an economic hardship or you don't? And he never said he did.
All right. Thank you very much, Mr. Brown. Thank you, Mr. Fox. The case is submitted.
hold on one second. I want to stop the, before you say anything.